Hello and welcome to the second video on police powers. In the first video we looked at everything up to the arrest, and in this video we're going to look at the arrest as well as things like detention, questioning and alternatives to prosecution. Now, while in the first video we did look a little bit at the European Convention on Human Rights, there's going to be a lot more focus on it this time. So when you arrest someone, that's obviously a deprivation of their liberty under Article 5 of the Convention. But this has to be balanced about allowing the police to be effective at doing their job. Similarly, in terms of the detention conditions, we're going to look at Article 2 and Article 3 as well. And so those are the sorts of things that we're going to consider, and things that you should consider putting in an essay or maybe even a problem question as well. Right, let's get started by looking at the different types of arrest. So there are three different types of arrest: a citizen's arrest, police arrest without a warrant, and police arrest with a warrant. Now, police arrest with a warrant is relatively straightforward. The police get the warrant and then go and arrest someone. So we're not really going to look at that in very much detail. Instead, I want to focus on citizen's arrest under Section 24A of PACE, and also police arrest without a warrant under Section 24 of PACE. So citizen's arrest first has three conditions attached to it. Firstly, an indictable offence has been or is being committed. So two parts to this. The indictable offence is a serious offence that can be tried before a Crown Court, and has been or is being committed. So the obvious omission there is you can't arrest someone as a citizen if you think someone is about to commit a criminal offence. It's only if it's taking place at the moment or has taken place in the recent past. Secondly, it's not reasonably practical for a police officer to make the arrest instead. So we're only dealing with situations where the police either aren't around or the person's about to make a getaway without the police having enough time to get there instead. Thirdly, certain conditions attached to the arrest itself. So that the arrest has to be effected in order to stop the person causing physical injury to himself or others, suffering physical injury, loss or damage to property, and running off before the police can arrive, which links back to the point 2. Now, we can usefully contrast this with the police powers of arrest without a warrant under Section 24. Whereas citizen's arrest only applies to indictable offences, police obviously can arrest someone for all offences. Also, in the same way that we talked about a citizen's arrest not applying to someone who's about to commit an offence, the same isn't true for the police, so they can arrest someone who is about to commit an offence. And thirdly, they can also arrest someone where there's a reasonable belief that an offence has been committed. So whereas a citizen has to be certain that an offence is being or has been committed by a particular person, the police are allowed to act on the basis of reasonable belief. Also, finally, before we move on from arrest, the reason for the arrest has to be one of those set out in Section 24.5. Now, if you go and look up that piece of legislation, you'll see that there's quite a long list there. It links back to the bullet points at the bottom of the previous slide, so preventing loss or damage of property, etc. But it does go a little bit further because obviously this is the police, and so they have to have a wider range of reasons available to them. So once a person is under arrest, then they have to be notified not only that they are under arrest, but also the reasons for the arrest as well. Failing to do this will make the arrest unlawful, as was seen in the case of Christie and Leachinsky from 1947. And there's also the caution that comes from the Code of Practice C, paragraph 10.5, and this is probably the famous caution that you might have seen on television different times. Do not have to say anything may harm your defence if you do not mention when questioned something which you later rely on in court. Anything you do say may be given in evidence. Now, this is a little bit controversial and has attracted criticism, so if you are writing an essay on this subject, it may be something that you want to pick up on, because it undermines the right to silence. So whereas under the American Constitution that's sort of protected as a constitutional right, the right to silence here is particularly undermined by the idea that if a person does remain silent, then that can potentially be used against them in a court of law, and an inference can be made by the jury. which is possibly not fair, but it does also encourage suspects to cooperate with the police and answer their questions. So I guess there's a balance there between the rights of the citizen to silence and also the effective prosecution of crime. So once a person has been detained, there's a maximum amount of time that a person can actually be detained for, and different authorities can give a different amount of time. So we can see there the custody officer, who will be the normal person in the station when a person is taken in, can offer a maximum time of 24 hours. And then this works up to the senior judge in relation to terrorism offences, and someone can be detained without charge for 14 days. This again is a little bit controversial and an interesting topic if you're thinking of an essay to write. It used to be 28 days, but it was taken down to 14 in 2012 by, I think it was the Protection of Freedoms Act. But this has been a long ongoing debate. So in the light of terrorism threats, how long should a person be detained without charge? And obviously this also relates to rights of liberty as well, and Article 5. So after the person is charged, the person should be brought before a magistrate's court as soon as practicable under Section 40. That's a useful thing to include in problem questions, just a standard thing that you can insert to pick up a few extra marks there. So the general rights that we have are the right to inform another person of the arrest under Section 56. So to let a family member know that you're okay is often really important. Perhaps people have dependents, and it's important to let them know that you're okay and that you're being held in a police station, and to let them make arrangements. Now this can be removed as a right if the police do worry that a person is going to make a phone call that will possibly put the investigation in jeopardy. But generally speaking, a person can inform another family member or friend that they are under arrest and at the police station. Section 58 covers the right to legal advice as well. This links to the right to a fair trial under Article 6, and so this was the point that was raised in Condron and UK 2001. Especially important in a criminal context, that a person does have legal representation to prevent abuse by the police. So the detention conditions link to Article 3 of the European Convention, which is the right to prevention of torture, but also inhuman and degrading treatment as well. So the conditions have to be one per cell with a toilet and washing facilities. And then also linked to the convention again, Article 2 is the right to life, and so the police have a duty to provide suicide watch in cases where they think that a person is at particular risk. And this was seen in the case of the Crown and Commissioner of Police of the Metropolis, 1999. So moving on from the detention and into the actual questioning, this can only take place at the police station under caution. So we talked about the caution earlier, you do not have to say anything, etc., etc. And at the police station, so if they start questioning the person, say in the police car on the way back to the station, that's not going to be allowed. The conditions of questioning are also quite similar in the same way that they have to be treating the prisoner or the suspect with a degree of respect in relation to Article 3. And so 8 hours free per every 24 hours. So that this is obviously to allow the suspect to sleep. Refreshments every couple of hours as well. Obviously that can vary a little bit depending on time of the day, etc., and when it's appropriate. Children and vulnerable adults have to be accompanied at all times when questioned, so that's obviously again linking to using the correct procedure and making sure that the investigation is fair. And review of the detention, so whether the person should actually remain under detention, has to take place after the first 6 hours, and then after that it has to take place every 9 hours. So it has to be constantly reviewed as to whether it is worthwhile to keep the person in detention. Section 76 and 78 relate to unfair evidence, and this is something that may be worth mentioning if some of those conditions aren't met. So if a confession is obtained by oppression, so police brutality would be an obvious instance, but there may be other examples of oppression as well. That comes under section 76, and therefore that confession cannot be admitted as evidence in the trial. And then under 78, this links back as well and says that any unfairly obtained evidence also cannot be admitted. So normally at this point, if they do decide to charge a person, that will then follow through with the prosecution and there will be a trial, etc. However, under police powers, it's important to remember that the police do have other powers in relation to alternatives to prosecution as well. So if they decide that the offence isn't very serious and not in the public interest at all to prosecute, then they can just decide to take no further action. And there may be a number of incidents where something silly has just happened, they've needed to arrest someone just to stop them at the time, but it might be their first offence and it may not have been very serious, so they'll just take no further action. Or they may give them an informal warning, just to sort of be on their way, but not to do something in particular ever again. Formal caution is a little bit different and would stay on a person's record. So in these cases, the offender has to admit the offence. There has to have been sufficient evidence to actually be able to prosecute it, and the offender then gives informed consent to the caution. And it also has to be in the public interest not to prosecute. So the police are actually taking a decision here not to prosecute someone and instead to give a caution. And that has to be in the public interest. So obviously in something like a murder or a rape trial, it's always going to be in the public interest to prosecute that because of the seriousness of the offence. However, if a person was maybe caught shoplifting, some very small items that weren't worth very much, then it may be in the public interest not to go through the whole criminal procedure, but instead to offer them instead a formal caution. So these cautions often have conditions attached to them, and these conditional cautions come under the Criminal Justice Act 2003, and there are essentially three types. So rehabilitation, which can involve some things like treatment for alcohol or drug dependency, anger management course. The idea behind it being that instead of punishing the offender, it's actually more in the public interest to try and rehabilitate them in some way. Reparation, maybe in cases of theft where the person, or damage to property where the person should just pay the victim back for the damage that they've done. And also there can be punishment ones, so the police can take punitive action themselves rather than going through the whole court process, and this can include things like financial penalties. And there we have police powers. If you're answering this as an essay question, then there should be loads of interesting stuff for you to pick up on, whether it's the apparent racism involved with stop and search powers, right through to whether the police should be allowed to give alternatives to prosecution, such as conditional cautions that exist completely outside of the normal criminal justice system. If you're answering this as a problem question, then try and follow the scenario through in a chronological fashion. So right from before the arrest and the possible stop and search and the reasonable suspicion involved, right through to when a suspect gets charged with an offence. I hope you've enjoyed this video. If you did, then remember to give it a like and subscribe for more videos in the future. And as ever, if you do have any questions, then leave those in the comments box below. Thanks again for watching. Bye!